Hello and welcome to ONCA 101, Removing a Director of an Ontario Nonprofit. My name is Benjamin Miller. I'm a lawyer who serves nonprofits and charities, and I'm of counsel with B.I.G Charity Law Group. In this video, I will look at ONCA, the Ontario Not-for-Profit Corporations Act, requirements for removing a director. Now, it shouldn't happen to you that you should have a director that you want or need to remove. But if it does happen, you want to be ready to do so quickly, efficiently, as painlessly as possible for all involved. So in this video, I'm going to go over 3 methods for how you can do that. Now, just a quick disclaimer, the following presentation is general legal information, not legal advice tailored to your specific situation. If you'd like advice or help with drafting any of the strategies we're going to discuss, then I suggest you reach out to a competent legal advisor. Now, at the end of this video, I'll share my contact information, and you can also go to charitylawgroup.ca. So method number 1, vote by the members. So members can remove a director with a 50% plus 1 vote. Generally speaking, you just need to call a members meeting, and you need to say in the notice for the members meeting that you will be discussing the removal of a director. And it's also good to give the director an opportunity to explain themselves. And if they're a director who's elected by one class of members, so let's say you have multiple classes of members, you have parent members and student members, or you have regionally divided members, Northern Ontario members, Southern Ontario members, for example, and the director is elected by one of those classes, so only the parents or only the students or only Northern Ontario or only Southern Ontario, then it's only that class of members that has the power to remove that director. So that's the simplest and most straightforward, but it can be difficult to call a members meeting, and it can also be a bit embarrassing to discuss all these things out in the open like that. So method number 2 is a bit less direct. So, your bylaws can require that your directors be members, and directors who cease to meet the qualifications for being directors cease to be directors. So, if you remove them as a director, then they also, if you remove them as a member, then they also stop being directors. So the question is, how do you remove somebody as a member? So to expel somebody as a member, to kick them out, firstly, you need to only do so based on the requirements for being a member. So you have to say what's required to be a member in the first place. One strategy is to say that all members have to sign a code of conduct. And you need to be very careful about how you write that code of conduct. You need to think about all the situations that might arise that might lead you to remove them as a member or remove somebody as a director. You need to set out in your bylaws who has the power to discipline members. Is it the board? Is it a committee of members? Is it a mixed committee of the board or the members? You need to set that out. And then when it comes to actually disciplining somebody as a member, you need to give them advance notice, at least 15 days under Ontario's Not-for-Profit Corporations Act, and then you need to give them an opportunity to respond, to share their side of the story. So you need to tell them why they might be disciplined, and then give them an opportunity to make arguments and provide evidence at least 5 days before the date of the decision. Then the committee decides and issues a final decision in writing, kicking them out as a member, and then if they're directors, and you need to be a member to be a director, this would also kick them out as a director. The final method is what's called a deemed resignation. So a board seat becomes empty when a director resigns. That gives rise to the question, well, what does it mean to resign? How do you resign? Your bylaws can say that a person is considered to have resigned if they do such and such. For example, it's common enough to say that if a director misses 3 meetings in a row, then they're deemed to have resigned. So you can list other kinds of things. Each of these methods has their advantages and disadvantages, and all of them can be set out in your bylaws so you have the option to benefit from all of them. If you have any questions about anything we've discussed, please reach out to me at benjamin.miller@charitylawgroup.ca or visit charitylawgroup.ca, and I'm sure we'd be happy to help.